Now, on the trend, since ICE was started its Human Rights Unit in 2003, over the last 8 years, would you say that the number of human rights violators entering or attempting to enter, Mr. Woods, the United States has increased, decreased, remained the same? What's the trend in your view?
I would say, depending upon the world area of the world you look at, the trends ebb and flow. When you look at the events of the 90s in the Balkans, and you look, they mostly entered in the later 90s. You look at the Rwanda events; they ended, right after 2000. Right now, like I said, we have 3,000 subject records to identify people who we feel are involved in human rights abuses that we have entered in for subject lookout records that we feel should not be admissible to the United States. 75 of those individuals attempted to obtain a visa or enter the United States and were denied. We don't see a huge increase, but I would say as you look forward into the future and you look at conflicts of today, just looking in today's media, you look at what's going on in Egypt and the conflicts that are going on there, you may see human rights abuses that will be cases that both Mr. Rosenbaum and I will be investigating and prosecuting in the future.
And can you speak to the mechanism, the visas, or what immigration mechanisms you have available to allow witnesses or victims to come to the United States if they wish to testify against a human rights violator in a criminal or in immigration proceeding?
Yeah, well, in consultation with the Department of Justice and our Office of Principal Legal Advisor, we make a decision on specific individuals, whether they're necessary or needed for whether it's an immigration hearing or a prosecution to be paroled into the United States. ICE has a law enforcement parole branch where we issue paroles to individuals to come in for those purposes.
Now, you testified that you have ICE attachés stationed in 48 U.S. embassies around the world. Can you tell us a little bit more of the role they play in overseas investigations?
Well, they're an extension of our domestic offices. Basically, the overseas investigators cover varied statutes, including human rights violations. They may be covering money laundering issues, narcotic smuggling issues, human smuggling issues, visa fraud. We cover 400 different statutes within the code that we enforce. So they serve as our special agents overseas. Additionally, in 19 different countries, we have visa security officers who review applications with the State Department for counterterrorism issues, and those visa security posts are co-located with the embassies and our attaché offices.
And Mr. Rosenbaum, the FBI has legal attachés in U.S. embassies around the world as well. What is their role in human rights violator investigations?
It's an increasingly important role. They're an invaluable resource for the Bureau as it ramps up its efforts in the human rights field through its comparatively new genocide and war crimes program. And there are many other FBI professionals who are not legal attachés who are involved in that effort, particularly in terms of assisting tribunals and foreign law enforcement authorities in investigating these cases. We did training, my office, in partnership with the FBI only a month or so ago in Bosnia. And it's really a force multiplier when we can have a few people training dozens or even hundreds of law enforcement professionals overseas.
And do you work on a regional basis, for instance, with trafficking of humans, for instance, where you have a group of countries, you provide help, expertise in those regions as well?
Human trafficking cases are primarily handled by the Civil Rights Division, and I'm not an authority on that. I suspect that they are handled that way. There is a limited amount of human trafficking work done in the criminal division, primarily by the child exploitation and obscenity section when it involves sexual exploitation of children.
And do you find that you have enough resources and support to carry out the FBI agents, attachés, carry out their duties?
We get outstanding support from the FBI. absolutely.
And what factors does DOJ take into account when deciding whether to either pursue a criminal charge before permitting extradition or to extradite an individual?
Well, we have actually a direction from Congress in the 2009 Human Rights Enforcement Act that we should consider extradition, and we do, for a variety of reasons. First of all, generally in law enforcement, it's considered desirable for an accused to be tried in the area in which the crimes were committed. That's more convenient for the witnesses, and it enables the community to see justice being done. It's also, of course, more cost-effective for our taxpayers to have crimes that were committed in other countries tried in those countries. But they're not mutually exclusive. There are instances in which we will prosecute and extradition may follow. It's really a case-by-case analysis, and our decision-making on the criminal prosecution side is governed by the United States Attorney's Manual, which lays out a variety of factors that we are to consider, including the gravity of the offense, the particular culpability of the individual, the prospects for deterrence because of the facts of the individual or the crime, possible alternative sanctions, and the like.
And what are the major problems you face if you want to pursue prosecution? I mean, is it a language barrier? What are your major obstacles in that?
I think we face all the obstacles that prosecutors the world over are familiar with, but in addition, there are special ones, including language issues. We employ a language coordinator to address those issues for us, and we do that very successfully, and we have for many years. We have sort of the cold case problem, not unique to these cases, but endemic to them. The crimes normally took place years and years ago. The evidentiary trail has generally grown cold. The crimes were committed far away from the United States. We don't have compulsory process, as we would have domestically, to compel witnesses to testify. We have witness protection issues that are unique to these cases because usually the witnesses live overseas. Some governments will cooperate in protecting witnesses, some will not. We have the issues that relate to the statutes themselves, which provide limited jurisdiction. As has been said, all of these statutes were enacted fairly late in the game. For instance, the genocide statute enacted in 1988, and it didn't become really operationally effective until December 2007. So in light of the fact that criminal laws are ordinarily have only prospective application unless they run afoul of the ex post facto clause, we can't employ the genocide statute in the case of Rwanda or, for that matter, the Nazi Holocaust. But we do intend to make full use of these Title 18 authorities, and I think you'll be seeing the fruits of the collaborative work that we do with ICE and the FBI very soon.
Thank you, Mr. Chairman.
Thank you. I have one more question, and I'm just trying to understand the role that both your agencies play, kind of proactively trying to deny people who may be implicated in human rights abuses, especially people who are pretty high up, from entering the United States. And we had we've done a couple of hearings here. One was on a case involving this guy Sheikh Issa from the United Arab Emirates, who not only was accused of torture, he used to like to videotape it, and on videotape, but he was a member of the royal family. We were not able to get a kind of a indication from the State Department whether or not they would not allow him to come to the United States, to go to New York City or to go to Washington, D.C. Is that a State Department call usually, or do you, Justice and Homeland Security, kind of proactively come in? The other case I'm thinking too is the case of Sergei Magnitsky in Russia. There are lots of people that are been implicated with pretty substantial evidence, I think, in his terrible death. Yet I'm not clear whether or not we have a policy that denies people who are pretty high up, some in the Russian government, some Russian businessmen, from entry to the United States. So in cases like that, how does it come about that we say no to those people? Do you proactively work with the State Department to say, you know, this is a bad guy, don't come in, or does the state have to come to you first? I mean, how does it work?
As I stated, when we have information, and I think when you asked earlier about the generals and how they got in 1989, 1990, and got passed without the people knowing. One of the great results of post 9/11 is interoperability and information sharing within government agencies, and we interface with the State Department on a daily basis on many of these decisions, whether it's related to human rights violations, whether it's related to individuals maybe suspect of narcotic smuggling, people that are suspected to be involved in terrorism. These issues have to be dealt with, whether to issue a visa or not to that individual. That authority lies within the State Department. We serve as advisors to them. For certain reasons and specific sites, the Secretary of Homeland Security can override, if it's a threat to the homeland, to deny a visa to someone. But when it comes to diplomatic issues and decisions of that nature, it lies within the State Department to make a final decision. And we do advise them through our interface with their visa system and through an interoperability working group that we have in Washington.
Yeah, I guess I asked the question because I think sometimes what might make sense kind of diplomatically, you know, so that you don't ruffle any feathers. You give somebody a visa to come in here, might not be the right thing to do because that individual may be involved, you know, in some terrible crimes. But it sounds like, I mean, obviously state's the lead in this. But I mean, we've been working on a number of cases where, I mean, I have no confidence, for example, that in the Magnitsky case in Russia, that there'll be, all of a sudden, justice will occur. I think, but I would like to think that at a minimum, those who are responsible for that crime know that others know, and that, you know, it may not be a jail sentence, but you can't come to the United States as a result of that, and you're not welcome in this country.
If I might address that, Mr. Chairman, also, in the criminal division for upwards of 30 years, we've been contributing names into the Consolidated Border Control Watch List system that's currently operated by state and by DHS. In the World War II cases, our staff historians assembled more than 70,000 names of suspected perpetrators of World War II-era Nazi and Japanese crimes, and those were entered into the system with the result that several hundred people were stopped at our borders trying to get in, and probably a larger number were denied visas in the first instance. In the cases of more recent conflicts, our historians have also gathered names, and they have contributed them to that system. In fact, in October of 2009, when the Senate subcommittee held its hearings, the ICE witness was the Assistant Secretary in charge of ICE, John Morton, who of course had an illustrious career at the Department of Justice Criminal Division before he was stolen away from us, and was well familiar with our work, and he specifically praised in his testimony what he called the critical work of our historians in gathering those names and providing them. But I will say on behalf of our terrific colleagues at ICE that they now do the lion's share of the work of gathering that information and getting those names into the system.
Well, I thank you both, and I want to repeat what I said at the beginning. I mean, we are really appreciative of the work that you do. We are grateful for the work that you do and the work that your staffs and everybody who's associated, you know, with your agencies do. It's very, very important work, and I think it reflects well on this country. I mean, I think if the United States stands for anything, it ought to stand out loud and foursquare for human rights, and you know that means that we hold people who commit human rights abuses accountable in whatever way we can. So I appreciate that, and I look forward to working with you on this issue of the statute of limitations, and maybe we can, you know, get something done to address what I think is, you know, a kind of an inadequate, you know, inadequate language in our statute. So, thank you very much. Appreciate it.
Thank you.
Thank you, Chairman.
We'll now call Pamela Merchant, who's the Executive Director of the Center for Justice and Accountability, and welcome her testimony.
Choice of chairs.
Good morning.
Good morning. You took the least comfortable chair.
I have a bad back, so this is the most comfortable chair for me. Good morning, Mr. Chairman and Representative Pitts. I would like to thank you and the members of the Commission for holding this incredibly important hearing on the government's efforts to investigate, prosecute, and remove human rights abusers. I've submitted a longer statement for the record. My name, obviously, is Pamela Merchant, and I'm the Executive Director of the Center for Justice and Accountability. I also spent 8 years as a federal prosecutor with their criminal division. CJA is a nonprofit legal organization dedicated to ending torture and seeking justice for human rights crimes. We represent hundreds of torture survivors. In the United States, we rely on the Alien Tort Statute and the Torture Victim Protection Act to bring civil lawsuits against human rights abusers who sought safe haven here. In addition, we work as a private prosecutor in Spain, and we're lead counsel on the Guatemalan genocide case and the Jesuits massacre case. And we're also now representing 45 civil parties in the second Khmer Rouge trial in Phnom Penh, scheduled to begin in January. CJA was founded in 1998 at a time when, with the exception of OSI and the World War II human rights abuses, this country was not actively prosecuting or removing human rights violators as they are today. And we applaud the efforts of the government right now to do this important work. At the time that we were founded, we were almost the only game in town to bring cases against these human rights abusers. The core problem that we address along with our colleagues at DOJ and DHS is impunity for perpetrators of gross human rights violations. By allowing human rights abusers to live with impunity, survivors and their communities are denied the right to truth, justice, and redress. As you noted in your opening remarks, Mr. Chairman, it's estimated that there are over 400,000 survivors of politically motivated torture in the United States. And we have quite a few human rights abusers who are living in the exact same communities, which obviously causes tremendous distress and undermines overall justice efforts. The only way real deterrence can be served is by holding these people accountable and holding senior members of the military accountable not only for their acts, but the acts of their troops under their command. We've worked very closely with DOJ and DHS over the years, and we support efforts to both direct more resources to human rights prosecutions and to expand the tools that are available to them so that we can effectively prosecute all the human rights abusers that are here. We also feel very strongly that these prosecutions should be looked at in a broad human rights framework, and as Mr. Rosenbaum stated, the part of this is balancing what are the criminal laws available here, what's the highest penalty that we can use here, but if there's another jurisdiction where there is also the potential of bringing a human rights prosecution, considering that as part of the analysis and working with those authorities in the context of extradition proceedings. If substantive crimes can't be addressed, then the next level would be looking at immigration charges, which tend to carry lower penalties, or they just are civil removal cases. It's imperative that Congress, and hopefully with the assistance of this commission, expand legislation to enable the prosecution of all human rights abusers. Almost all of the defendants in the cases that CJA has brought, which include Generals Vitas Casanova and Garcia, could not be prosecuted in the United States today because of the limitations on the law. And in the case of General Vitas Casanova and Garcia, they were tried by a federal criminal jury in Florida. In the second trial against them. They were held accountable for crimes against humanity and torture. They are now facing, and we applaud the fact that they're facing removal proceedings by DHS, but that's civil, and what will happen if they prevail is they'll be removed from the country and they'll send back to El Salvador where they'll remain free because of the amnesty laws there. And that's just not enough from our perspective. So to that end, we, as we say in our written statement, we urge a number of legislative fixes. The passage of a Crimes Against Humanity statute. Senator Durbin introduced legislation in the 111th Congress. We also, passing of a criminal extrajudicial killing statute. Right now, it's a crime to torture, but not to kill somebody in another country. There should be no statute of limitations on these atrocity crimes, as is the case with common law murder, where there's no statute of limitations. And the application of these laws should be retroactive to at least the Nuremberg context. The world has been on notice for a long time that torture is illegal. Command responsibility is an incredibly important doctrine in these cases and should be incorporated as a basis for liability. In addition, the ICE's immigration form should be amended to add language that asks questions about a military officer's role as a commander of overseeing troops that are involved in human rights atrocities. We hope that the existing legislation that we have be more rigorously enforced, if possible, recognizing the difficulty of doing these cases. It's still true that there's only been one torture case brought under the 1994 Torture Act. We also encourage cooperation with other governments, and as Mr. Rosenbaum stated, the Human Rights Enforcement Act of 2009 directs DOJ to consider extradition. We think, as Mr. McGovern just said, that it's important in the case of Colonel Montano and also Lieutenant Cuenco Ocampo, who is in the San Francisco Bay Area. These are both defendants in the Jesuits massacre case in Spain. They are both subject to arrest warrants and indictments, and we believe strongly that justice will be served more appropriately for them to stand trial in Spain on these more serious charges than on the immigration charges here, which doesn't mean they shouldn't also be subject to immigration charges. I don't mean to suggest that. It's just that if you're weighing all of these things. And we appreciate any efforts the Commission can use to use its influence to ensure that the extradition requests, once they come down, are honored. I also would just like to take this opportunity to acknowledge the critical role that the U.S. Congress and Chairman McGovern played in the investigation of the Jesuits massacre case and subsequent accountability efforts for El Salvador. Had that investigation not happened, it's not clear that we would be here today and have a government in El Salvador that is open to change and for hopefully to start dealing with human rights abuses from that era. I just want to raise one other example that we mentioned in our testimony. The senior members of the AUC, former paramilitary groups from Colombia, were all extradited to the United States to face narco-trafficking charges. They had been part of the peace and justice process in Colombia. Almost all of them have already confessed to extraordinary human rights crimes. It's our opinion that our government should have deferred the human rights crime context over the drug crime context. Because they've been pulled out of the peace and justice process, they're not being prosecuted for human rights crimes, and they likely will not. And that is a situation for us that if there had been better coordination with the human rights units that have testified here today and the narco-trafficking people, maybe they would still be in Colombia facing what we consider to be more serious charges. And finally, just one last point. These are very difficult cases to bring, partly because they're historic and mostly because of the witnesses and the survivors suffer from post-traumatic stress and extreme anxiety. So we also encourage all efforts to be done to do training with the investigators and asylum officers and everybody that comes into these cases on how to work with people who can be re-traumatized by having to testify again and again. And also it's extraordinarily important to put strong safety protocols into place to support these witnesses and their families. Thank you very much for inviting the Center for Justice and Accountability, and I'm happy to answer any questions.
Well, thank you very much, and we have great respect for the Center for Justice and Accountability and the work that you and everybody who works with you do. So I want to make sure that's clear for the record. Thank you for your kind words about my involvement in the investigation of the Jesuit murders. We were together, as you reminded me. I think it was the 20th anniversary.
Yes, 20th anniversary.
So it was 20th. It's hard to believe it was over 20 years since that had happened. And one of the things that to this day bothers me about that case is that really nobody had to pay a price for it. Even the few that were actually convicted in a court of law were all granted an amnesty, and it just seems to me that that when people commit those kinds of crimes, they ought to be held to account. And I don't think that was a crime that should have been subject to an amnesty. But in any event, that's why this case that you cited in Spain is so important, because I think that may be the only opportunity. You also mentioned the case of the AUC members from Colombia, which has been a great concern to me. I want to make sure that we get the narco traffickers, and the United States has extradited a number of narco traffickers from Colombia to the United States with the cooperation of the Colombian government. But as you mentioned, many of those people were involved in massacres and in crimes against humanity. And when they come up here and they're being tried on drug charges, they're told by their counsel to not answer questions about anything else, to stick to the subject. And one of the things that gets sacrificed, in addition to being held to account for human rights abuses, is that truth oftentimes gets sacrificed. You have the victims and the families of victims who want to know what happened, and oftentimes these people are the only ones who know where they committed a massacre or where they tortured somebody or buried somebody. And I think it's important that at a minimum that the truth be known, and I worry that the way we've been doing things here is that not only will they not be tried on human rights abuses, but we're not going to know what happened. A lot of people will not know what happened to their loved ones who have disappeared. And we have had conversations, just so you know, with Justice Department about that. Trying to encourage the United States to make sure that that they're held account for the drug stuff, but also that they cooperate with the Colombian activities. Colombian authorities. I'm not sure that that's happening, unfortunately. You had mentioned that there are situations in which victims and human rights perpetrators from other countries kind of are within the same communities, or have come into unexpected and accidental contact with each other. Can you give the committee some examples of that?
Yeah. CJA was founded by a torture treatment therapist, Jerry Gray, and who treats torture survivors. He had a client who'd been in a Bosnian detention camp who he was treating, and he got a call, Jerry, one day from San Francisco General. His client was in the emergency room. He had just had a psychotic break because he ran into the guy who tortured him in Bosnia. It was the exact person who was his torturer, was also living in San Francisco. And that's the genesis of the Center for Justice and Accountability being founded, was Jerry's realization that torture survivors can't fully heal and have a therapeutic experience as long as their torturers are wandering the streets. Another example, Colonel Carl Durelian, who was a member of the High Command in Haiti and played an active role in the Rabateau massacre, he became known to us because he was on TV in Florida having won the lottery. And this man is he's actually back in Haiti, but he was a notorious war criminal that had been prosecuted in Haiti, and then after there was a coup, had escaped and come to the United States. Everybody knew him in Haiti. I mean, we obviously don't necessarily know who the war criminals are here, but he's on TV holding a lottery, a big check on TV. It's very re-traumatizing for people in the communities to know that this country that has granted asylum to so many has at different times also let the perpetrators in.
Can you tell us, in addition to CJA, what other NGOs or entities provide useful support to the U.S. law enforcement vis-a-vis human rights violators?
You know, I guess I don't for sure know the answer to that, but the Center, I assume the Center for Victims of Torture and the National Consortium of Torture Treatment Providers, I would assume WOLA.
Right.
The Minnesota Advocates, which has another name now, I think, has done a lot of work around the Liberian community. I mean, I would say that in the NGO community, FAST is very supportive of efforts of the government. And one of the tricks in all this work, though, is getting the trust of the survivor communities, right. And that can take many years.
And just so we understand, you talked about a good working relationship with the U.S. governmental agencies. Can you tell us what that means? I mean, how do you? I mean, do you go to them with ideas, or they come to you asking for help, or how does it all work, or both?
I would say that it's both. We've for years been actively pushing for certain types of, in the context of certain defendants, like Vitas Casanova and Garcia, but also Colonel Carranza from El Salvador. There's just a long list of them, and we've testified before Senator Durbin's committee, and we provide evidence. Our clients, two of our clients testified in the case against Vitas Casanova. 4 of our clients were interviewed by DHS officials in preparing for that. Our attorneys go and are there with the clients to help. We, in many situations, convince our clients to come in. In the case of Vitas Casanova, one flew in from Sweden and another from El Salvador. It's very hard for them to make a decision to testify in these cases, so we work with them and provide as much support as we can, and torture treatment therapists. But we've also opened up our files. The government has been helpful for us in situations of bringing in our clients and sometimes witnesses to testify in human rights cases that we are bringing. Is that answering?
Yeah, that is. No, that's great. Do you or people in your organization get threats?
Our clients do and witnesses do. We don't as the attorneys, but we often have situations where we can't go forward because of the threats. And the Chucky Taylor case is an example. We had a client who had been directly tortured by Chucky Taylor, and his family was receiving so many threats that he couldn't participate anymore safely unless there was a way to protect his family. And so one of our ultimate concerns is that there be some kind of a expansion of the U-Visa program so that people who are participating in these human rights prosecutions, civil and criminal, also have a mechanism for protecting their family if necessary.
Well, my last question you already answered in your testimony, which was what can Congress do? And what I'd like to ask is that just as the 2 previous witnesses said, they'd be willing to work with us on dealing with issues like the statute of limitations stuff, that we could work with you on some language that we can maybe kind of close some of these loopholes and address some of these inadequacies in the law. If that's...
We would be honored to help in those efforts.
Mr. Pitts?
Thank you, Mr. Chairman. Thank you for your testimony. Regarding our law, or the interpretation of our law, specifically material support for people seeking asylum, saying, for instance, when they are under compulsion to serve as a domestic servant, threat, rape, or threat of sexual assault, that you've given material support to these perpetrators of human rights violence. Therefore, you are denied, asylum here. Do you have any thoughts about how our law is being?
I'm not an expert in this area. However, we don't feel in the human rights community that it's being applied appropriately in every instance. My impression is that there are so many different agencies who deal with these issues, and the people that are here today are more sensitized to how It can be in the home country where you're living under death squads or paramilitary troops and you have to cooperate. But it's an extraordinarily difficult situation for people living in war-torn countries, and we would. There have been some examples in the press that I'm sure you're aware of where people are just caught up in what's going on around them, and it should not. Sometimes you do have to feed the soldiers that come and camp in your yard. Yeah.
You mentioned safety protocols. What action should be taken to protect victims or witnesses from threats of violence against them for participating in a proceeding against the perpetrators?
My sense is the best example we have is what we do in organized crime situations. So that if people want to go into a witness protection program, if they want to change their identity to provide safety for their family, I think looking at if you're going to bring somebody in to testify, if it would be too dangerous for them to go back, that they could stay and that their family could come as well. It can be extremely dangerous. We're working with somebody right now who testified before the tribunal for Rwanda in Arusha as a protected witness and is now here in the United States, and his identity has become public, and it will chill our ability to do these cases if we can't secure the protection of some of the key witnesses.
Could you elaborate on several types of best practices for U.S. law enforcement to follow when dealing with the foreign witness, victim witnesses during criminal or immigration investigations proceedings?
Yes, one thing is to have a good sense of what the situation is that they've faced. So to do your homework about who was on what side and what the nature was of the violence. The other thing is translation is very important. So to be able to speak in the language of the people you're talking to avoid having people tell the story of how they're tortured over and over and over again. It's the type of story that you need to know, but you don't need to know it over and over and over again. There's a lot of turnover in these cases, and every time a new agent comes on, there's a tendency to want to re-interview the witness. It's extraordinarily re-traumatizing. Anybody who's gone through an asylum hearing in this country is probably already afraid of the government again. They're afraid of the government because of what happened to them in their own country, but then they come here, and that can be a very difficult situation because you're not assumed to be telling the truth almost. So I think some of it is just being really conscious of the fact that if somebody has already told how they were brutally tortured, you can probably save that story again for trial and not have to have them keep going through it again and again. And then the other part that's really hard, I think, is how to prepare somebody for cross-examination, and that has to be done gently, and there needs to be a lot of time spent with witnesses, more than often you're used to. My background was white-collar prosecution, and we spent a lot of time with witnesses, but there's nothing like the amount of time you need to spend with people who suffer from PTSD.
Would you expand a little bit on the role of civil litigation regarding in holding human rights violators accountable?
The civil litigation that we do or that the government does?
Well, that you do.
So the civil litigation that we do is, we can only do it if the defendant is here in the country, and we can bring it on behalf of aliens in other countries or U.S. citizens and aliens that are here in the United States. It's very therapeutic, I think, for the clients, and it's a truth-telling. It's what Chairman McGovern said. It's an opportunity to create a record of truth about what happened and to shine a light on abuses that have not yet been addressed, and to support, hopefully, justice efforts in the home country. Oftentimes, the cases that we do here end up becoming part of a prosecution in another country. In the Acamarca massacre case, for example, from Peru, we brought 2 cases in the United States. one in Maryland and one in Florida, and the government also brought removal cases. We helped. We had one of our cases went to trial here. We received a judgment. The evidence we developed there is being used in a prosecution right now in Peru. Both of those defendants are on trial right now in Peru on human rights crimes, and one of our attorneys was just down there a couple weeks ago helping do witness preparation, because the ultimate goal is to have these people held accountable in their home country so that impunity is ended, and also there's more and more evidence that countries that have had accountability mechanisms in place become less violent. So Argentina and Chile, where they've had many prosecutions now of human rights abuses, have a much lower violence rate than Guatemala and El Salvador, where there hasn't been any justice efforts. And social scientists are studying this, but it seems clear that if there's if people are held to account, the violence rate ultimately goes down.
Thank you, Mr. Chairman. Excellent testimony today.
Well, thank you. And I just have one last question, and that is the question is about politics. You know, during the 1980s, the asylum success rate for Salvadorans was fairly low, and one might argue was because the United States had a very close relationship with the government, and so kind of acknowledging that you had all these human rights cases was kind of acknowledging that there was a problem within some of the institutions in the government. I'm just wondering on, you know, and again, it doesn't matter who's in the White House, but the question to me is, I mean, are there cases where you feel we're not moving forward on because we have a close relationship with the government, that, you know, that a political decision is being made not to pursue things, or do you think we're beyond that now?
Iraq was a situation where we weren't granting asylum as quickly as people thought we should have, and then that's changed. There was pressure put on the government. I think there's been movement. The big open area right now are victims of all the drug violence in Mexico, and whether we should be opening our doors to people who are not victims of state-sponsored violence, but of drug war violence. I think that's a big question. And I'm outside of my general area of expertise, but I would say it's always a struggle. And but I would also, when we're letting people into this country, the worthy people, in my opinion, are people who can't live safely in their own country, and they, as you know, don't choose. Nobody really wants to leave their country because of that reason, and we've welcomed so many people over the years, and it's one of the gifts that we can provide.
Well, I thank you, and I thank CJA for
the
incredible work, and we appreciate your testimony.
Thank you very, very much.
Thanks. Thanks.
Seen you forever. What have you been up to?